Welcome to Legal Action. My name is David Siegel, joined by my co-host Jesse Barrientes. How are you, Jesse?
Oh, really good, Dave. How about yourself?
Fantastic. Today we're going to be talking about Chapter 7 bankruptcy, which is the relief afforded to get a fresh start under the United States Bankruptcy Code. Jesse, we are in very tough economic times. Unemployment is rampant. What are you seeing in your office in terms of Chapter 7 bankruptcy clientele?
There's a lot of people who are eligible and who need to be able to discharge those debts so that they can get a fresh start. You know, in this economy, everybody is in the same position because of the real estate market and everything else. There's a lot of folks who are having issues and who are behind on their mortgage, and a lot of the companies, the mortgage companies, aren't as diligent as maybe they should be in order to do the modification of their loans.
When people come to see you, they're very upset, they're stressed out, they're unsure of their future. What's the most important thing that they need to do when they come into your office in terms of giving you information? Why is this so important to give you the exact information on their case?
Well, and we have them fill out an intake form, which is kind of lengthy, but what I need to know, and what any bankruptcy attorney needs to know, is the exact what they make. There's a lot of different things, but I need that information in order to determine whether or not they're eligible, and if they are eligible, for which chapter, either Chapter 7, which is what we're talking about this evening, or a Chapter 13, which I think we're going to discuss on another show.
Okay. Well, if somebody's a homeowner, they own a home, they're making their mortgage payments on time, would a person like that be eligible to file a Chapter 7 and wipe out a lot of unsecured debt?
Absolutely, they would. There are some other conditions, and we're going to need to know about how much equity is in their home, because they would have an exemption. It's $15,000 per homeowner. So if it's a husband and wife, even if both of them are not filing a bankruptcy, they can have as much as $30,000 in equity. Actually, they can have more, because in order for the bankruptcy trustee to make it worth their while to sell the property to pay some of the creditors, they're going to have to incur expenses with respect to the real estate agent. They're going to have to incur closing expenses and all that. So typically 5 or 6% you can kind of gauge that, and they're really not going to sell your home in this market, especially for a few $1,000s.
I just want to emphasize for our listening audience and our viewing audience the term equity that you mentioned. Equity is ownership in the property. So if the property is worth $200,000 and the mortgage is $150,000, that would mean you have $50,000 worth of equity, correct? The difference between the market value and what's owed is your equity or your ownership. Is that correct?
That's correct, too. And you need to take in consideration the a second mortgage. A lot of folks have a line of equity, second mortgage, and so we need to kind of look at that as well, just to be absolutely sure what they have. But you know, a lot of people think, and it's getting the value of their home. I've had people come in and I ask, well, how did you get this value? Where did you get it? They just pull it out of the air.
Yeah. Well, I think the viewers should understand that there is a website, Zillow.com, Zillow.com, which gives a pretty good estimate as to what the market value is. And in fact, that's what a lot of the trustees look at when they receive a bankruptcy case to determine the value of the house. They're going to go on Zillow.com and get an estimate, and if they're unsure, then they'll go get a private realtor to come and give an evaluation. But it's very important. Anybody can go to www.zillow.com to get an average market value of their home.
You know, and it's important too, because if you do have an appraisal, that's going to run you, again, depends upon the appraiser, probably about $300 or so. A lot of people sometimes think, oh, well, I just had my home refinanced and this is what they said the value was. But people don't understand that the value really that you get for a refinance is different than the value that you really, you know, would get from an appraiser or from somebody else. The bank really wants to, and that's how I think we got into this big real estate mess, they really want to loan you the money. And
Sure.
So if it's not worth it, so sometimes those appraisals kind of go a little bit more than they should. But you know, another way to find that out is to be able to talk to a real estate agent and find out what the value of your home is. And what they're going to do is they're going to compare your home, the structure, the square footage, the style, and everything else with other homes in the area, about maybe a mile and a half radius or so, and they're going to come up with a value. They're going to look at also the other homes that are similar, what they've sold for and when they sold for, and everything else. And remember, a realtor wants to price it to sell because they want to make their commission.
Okay. So let's say there's not significant equity in the home and the person can file a Chapter 7. What sort of debts are eliminated in a typical Chapter 7 bankruptcy case?
Well, if you have if you don't have too much in terms of the equity in the house and you're good on that aspect, you can discharge your unsecured debt. Unsecured debt is, for example, would be your credit card, would be some other maybe personal loans that you have, things that you have not secured with property or with your home, those kind of things. But in Chapter 7 bankruptcy, you can pay, or rather that'll be discharged. We're going to talk about the range in the Chapter 13 on the next show. But that would be discharged. Some of the things that cannot be discharged, and that's important for people to know as well.
What type of debts cannot be eliminated in a Chapter 7 bankruptcy?
Student loans, taxes, and I've had recently a few of these, so it's important. Tollway fines, because sometimes people go through it, they don't pay it, and then they double and everything else. Those are not going to be able to be eliminated in those things.
So tollway fines have to be paid back in full, or they're not eliminated in Chapter 7?
They're just not eliminated in Chapter 7. And sometimes I've had people that came in that were with substantial amounts on that, on the tollway. Domestic support obligation, which is child support or maintenance, are not dischargeable in bankruptcy. So if you're in arrears or somebody's behind in child support, whatever amount, that's not going to be discharged whatsoever.
Well, that would make sense because the courts and the country want to look out for children and make sure they're supported. So whenever there's a child support obligation, that debt has to be paid in full at some point. It can never be eliminated.
Right, as it should be, especially, child support. When you look at that, the support is for the child. You have an obligation. We've talked about this in other shows. A parent has an obligation to take care of his child. And so it makes sense, and it's great that those are not discharged. Because I really tell you, if it were dischargeable, I think there'd be a whole nother niche or area, a bankruptcy law, where people would just be coming in to discharge those obligations.
What about attorney's fees? Can attorney's fees be eliminated in a Chapter 7 bankruptcy case?
For me, to tell you, sadly, yes, they can.
What do you mean by
that? Well, it's sad. And actually, just recently, I had one, live by the sword, die by the sword, Dave.
Yes.
I had one recently discharged. It wasn't like it was unexpected, probably in excess of $20,000. But again, that's the system that's been put into place. Attorney's fees for your own attorney can be discharged. Attorney's fees, however, that you're ordered to pay or to contribute to the other side in the form of support to that other person cannot be discharged, nor, I believe, can fees for the GAL garden ad litem. We'll probably talk about that on one of our shows when we talk about those type of garden ad litem is an attorney for the child. So those cannot be, or they're simply just not discharged and they're collectible.
Is this why in a typical Chapter 7 bankruptcy case, the attorney's fees that the client pays you have to be paid in full before you file the case? Is that the reason?
If you do that, and then this is what I tell people, I say everything has to be paid in full before we file it, because then the firm is going to be a creditor. And if it gets filed, then that's subject to discharge, because the debt actually was really incurred pre-petition.
So this is why attorneys want to get paid before they file the case. Otherwise, their debt is typically eliminated.
That's correct.
Absent some kind of agreement to the contrary.
Right, or a reaffirmation agreement, which probably isn't going to happen.
Okay. Let's talk about what happens when you actually file the case. What happens next?
Well, you come in, and there are a lot of things. Let's talk about, though, before we file the case, because I think it's important for them to know, there is a requirement when they passed the Bankruptcy Reform Act. I don't know, how long has it been now, Dave?
October 17, 2005.
Wow, you remember that date pretty well.
Absolutely.
Yeah. So it's been a couple years, a few years. It just doesn't seem how that time gets behind you. But you're required now to take a debt management class and then a credit counseling class, or credit counseling and then debt management. And it provides, it's a precursor. You have to take that before you can actually even file the case.
Okay, let's talk about this. What is the credit counseling requirement that you have to take? What does it entail? What does it cost? How long does it take? And when do you have to take it?
You can take it on the computer over the internet, and it'll cost, I believe it's $50. And they just want to get information from you, all of your financial information and everything else. In fact, I believe that my office, your office too, probably sends out information that they need to have together before they take that class. And I don't know, Dave, would you say probably about an hour or so, maybe two, depending upon how efficient you can type all of that stuff in?
The average credit counseling session is about an hour if you do it online, maybe a little bit quicker if you do it over the telephone or in person.
So once you get all that information done, and then they will give you a certificate. I know some attorneys send attorney code that you have that's unique to that firm, and what happens is that place the credit counseling will automatically email it or send it to that firm.
That's correct. That makes it very easy for the attorney to figure out that you've actually taken it and give you proper credit for it.
Exactly. And then so that's before you can even file the petition. And then after that, before you get your discharge, you're required to take a debt management course, and that that costs you about $50 too. And Dave, I believe that you're one of the only people or attorneys that I'm aware of that is an accredited provider of that debt management course.
Yes, I do provide that course. I do teach the 2-hour financial management class. I'm an accredited financial counselor, which allows me the accreditation to be able to do that. And the class is a full 2 hours, talking everything from finance to budgeting to purchasing a car, purchasing a home, so that people make smart decisions after they file a bankruptcy so they don't fall into debt again. That is the idea, to educate people so they don't have a problem in the future.
Right, because again, if people just kind of complain and whine and cry, nothing is going to happen, right?
That's right.
You have to address those issues that are before you and take a positive action rather than just wait for the barrage of things to happen. And it's fairly stressful. We can say that kind of on the side when you have debt collectors calling you and you have people trying to collect, and they're calling you at work, and they're calling you at home, and they're calling you maybe if they have your cell number too. It gets to be quite stressful, and I think health hazard as well.
It does. It gets very stressful. And some of these creditors go over the top and violate federal law when they're trying to collect on these debts, and that's really unfortunate. They can be sued under the Fair Debt Collection Practices Act, but it's hard to find an attorney who's willing to bring that case when it's only $1,000 per violation, basically.
Right. They're going to do all that work, which is going to exceed $1,000 unless they have a class action and there's been a pattern, or unless it's a really egregious
Attorney's fees are allowed as well, so you will collect attorney's fees, but suffice to say, there's a lot of collectors out there that are violating the law. But now that we're up to the filing of the case, you file it electronically through the court system, through the computer. You're issued a court date that the client has to appear to. And what kind of notice goes out to everybody that basically says, hey, a case is filed, stop your collection activities immediately?
Everybody gets a notice of the stay, which is that notice that you're talking about that says, that identifies the individual or individuals who filed it. It identifies the case number. It identifies the court. It identifies the bankruptcy trustee, the attorney for the debtor who filed the petition. It also has what they call a 341 meeting date. 341 meeting refers to the section that basically it's a meeting of creditors. And when you go in on that date for Chapter 7, it's really not, I wouldn't really say it's a court date. It's I think, a little bit more formal than a court date. But you go in, and then there's the bankruptcy trustee who's ever appointed, and there is the debtor, and then the debtor's attorney.
What is the role of that Chapter 7 bankruptcy trustee in this whole process? What is their duty and obligation?
His duty and obligation is to determine whether or not it's a no-asset case, or whether or not there are assets that can be liquidated in order to compensate the creditors for the credit that they've extended, or which either way, either unsecured or secured.
And so our viewers are not alarmed. 99% of all Chapter 7 bankruptcy cases are no asset cases. The debtors, the individuals, get to keep all of their property, and they don't lose anything in a typical Chapter 7 case.
That's correct. And I think it's important to note, as long as we're on that kind of score, on that issue, we need to know about the equity in certain things. We talked about the house. As long as you don't have enough equity, you're okay on that. It's important to note, too, that when they passed the Bankruptcy Reform Act in 2005, October 17th, is that what you said?
That's correct.
See? Oh boy, it just stuck right in my head there too. They also establish certain income levels. So basically, you have to, if you earn a certain amount of money, you are presumed that you cannot file a Chapter 7 bankruptcy, which is complete discharge. You have to file a Chapter 13, which is a consolidation. We'll talk about that on the next show, in fact. But that's what's important. So when you have those issues kind of going on, you want to make sure that everything is taken care of. You want to look at your car, because sometimes people might have, and let me ask you, what's the exemption for an automobile? What happens, Dave, if I have a car, and typically what I see, and I'm sure that's what you see too, is you have a car that's you owe $15,000 on, and it's worth maybe 10 or 8. Sometimes you might even have a car that somebody had paid off. So what happens if I've got $8,000, my car's paid off and it's actually worth $8,000?
Well, we can protect up to $2,400 in one vehicle, and then you have what's known as a wild card catch-all exemption of $4,000 that could be put on any type of property other than real estate. So 24 plus the 4,000, I could probably protect at a maximum $6,400 worth of equity in that vehicle.
Well, let me ask you, now in this example I said that we had 8, so is the trustee going to sell my vehicle?
No, because there's not enough equity. It's not worth the trustee's while to go ahead and list it, sell it, and pay a dividend to creditors. There just wouldn't be enough there. But if there's, 4, 5, 6,000, then maybe it's worthwhile, depending on how much you owe.
And that you have equity in the vehicle.
Right.
Okay, and that applies then. So if I have, let's say I had that car, and let's say I had a Harley-Davidson motorcycle that was paid, and that was worth $25,000, we'd have the same issue there. That's probably something
Exactly.
to sell it for.
Right. And anytime we find that someone has that kind of property, we would advise them not to file a Chapter 7, because the Chapter 7 trustee is definitely going to acquire that vehicle or piece of property and liquidate it. And there's nothing you can do once the trustee finds an asset. You can't dismiss your case. You don't necessarily have the right to automatically convert it to a repayment plan under Chapter 13. You have to be very careful that when you file a Chapter 7, you have no significant assets that are going to be taken. And if you do have assets, the attorney's probably going to want you to sign an asset acknowledgement form where you realize that there's a chance you might lose some property in this Chapter 7 Fresh Start case.
So the person doesn't say later on, you never told me this.
Exactly, or worse, you told me it would be okay.
Right.
I told you I had it paid off Harley, and you told me it wouldn't be a problem. The trustee wouldn't want it. So that's what it is. It's protection for the attorney to make sure that they don't have any false claims against them.
So if I inherited Grandpa's Harley-Davidson classic motorcycle, right, then I'm going to want to make sure that I see what the value is before I do anything like that.
Yeah, and the court's reasoning is, the trustee's reasoning is, you could liquidate that piece of property and pay your creditors, as opposed to just eliminating your debt and keeping that property. So you can't have your cake and eat it too. You can't have too much in terms of property. You can't have too much equity in real estate. You can't have too much cash on hand or monies on account. It's for honest debtors who fall within a certain limit in terms of what they make and what they own. Okay? It affords honest debtors a fresh start. That's what Chapter 7 is all about.
Let's get back to that point where I told you about, we were talking about the certain income level for different, for an individual filing, and that increases depending upon how many people are in your household.
Yes.
Well, and what happens if I'm above that level?
If you are making more than the median for a family of your size, then you have to submit to a means test, which is a mathematical calculation based on IRS allowances for food, clothing, and housing, and transportation, to make sure that you don't have the ability to pay something back to your creditors. In other words, you might be spending way too much on transportation and housing, and the means test kind of knocks those numbers down as to what the IRS allows.
Well, let me ask you this. For example, for one person, it's for food, it's $350, and then for each additional person in the household, another $50. Well, I can tell you, when I go to Whole Foods, I plop down probably, $100 a plop, even more, depending upon what that is. That's more than once a month there. So maybe I spend $600 or $700 for just one person. What is that going to do?
Well, the IRS allowance for food is going to be a lot less than what you actually spend for food. These allowances come into play when the IRS is collecting on a tax debt. So they have no incentive to give you a lot of food budget. They want you to eat as little as possible or have a minimal amount in your budget so that there's more that they can collect in terms of a tax. So the bankruptcy code is utilizing the same IRS standards that the IRS uses to collect on taxes. So obviously it's not, steak and lobster, Jesse, is out. You are going on ramen noodles, mac and cheese, sack of potatoes, and some bread, and that's it until you repay your debt.
But we're talking right here for the Chapter 7. I'm trying to discharge my debt.
You are going to discharge your debt, but if you're spending too much on food and you're making a lot of money, the court basically says you're not entitled to a Chapter 7. You're not going to be able to walk away from your debt because you can pay a little bit back if you budgeted properly under the IRS guidelines.
So that's basically designed for people who are making a lot of money. So if I was making 150 or 200 or whatever, and okay, I just want to discharge these debts, well, they're not going to let me because I have the ability to pay that back.
That is correct. But if something were to happen and you lose your job, you become unemployed, and your average income over the 6 months falls below the median, or even above the median if you pass the means test, then you will get a fresh start. So income is a big factor, but so are your assets and your debts.
Well, wait a minute. If we're talking about over a 6-month period of time, but wait a minute, I might have been making all that money then, but I just got canned. I just got fired. And so you're telling me that I have to wait 6 months in order to qualify?
That's right, because it's a look-back period of 6 months. So if you're making good money for 5 months and all of a sudden this most recent month you're not making money, your average over the 6-month period is still going to be excessive. So you might have to wait. And that's what people do. They wait to file sometimes. They time it. They find a way to file under the current law.
So it's just a little bit of time if I don't have a particular urgency involved.
Right. And as long as you didn't quit your job or as long as you didn't fail to get a job when you could, as long as you're not doing anything fraudulent,
right,
then it is permissible to wait out the necessary time period, fall within the means to be able to file, and get a Chapter 7 fresh start.
Okay, so there's a lot of things that people aren't really aware of that are very important, and they don't have that idea. How easy it is for somebody to do it on their own?
It's very difficult. The forms are voluminous. You have to know how to fill them out. It's not as simple as just listing what you own and what you owe. There's Illinois state exemptions that have to be listed, and that's based on your property. So you have to understand the law, and most importantly, you have to understand the process. Some people file on their own. They don't take the credit counseling. The case is dismissed. There's timing on when things have to be done.
So they dismiss the case. So let's go back and talk about that. Do you mean it gets dismissed involuntarily?
The court will dismiss it, either on the court's own motion or on the trustee's motion, because you did not take the credit counseling within 180 days prior to filing.
What happens if I took the course, or I filed it the same day and the same day I took the course?
Most likely you'll be okay. There is case law on both sides, but for the most part you'll be okay. I would not recommend that though. If I was your attorney, I would make sure at least 1 calendar day passes. And that means you can take the credit counseling at 11 o'clock on a Monday, and I could file you Tuesday at the stroke of midnight. So it really could be an hour, but it's got to be 1 calendar day apart.
But definitely, I can't go ahead and file it and then take the class the next day. What would happen if I did that?
You would be ineligible when you filed because you didn't have the prerequisite or the requirement of the credit counseling. Your case would be dismissed.
And they'd make me refile?
Yes. You would lose your filing fee. You would lose any amount that you paid to an attorney if an attorney did this for you. So you got to be very careful. That's why, Jesse, you need to go to a reputable attorney, someone who practices bankruptcy law on an everyday basis, who understands the ins and outs of the code, the system, and the procedures so that you have a successful Chapter 7 case. There's nothing worse than filing a Chapter 7 case and having problems. Right. You want your Chapter 7 case to go smoothly. You want it to be the only time you ever have to file a Chapter 7. You want to get the fresh start that the government has afforded you under federal law. And you want to be successful going forward and prosperous and be able to provide for yourself and for your family and be a good member of society, a good member of your church, a good father, a good sibling, a good spouse.
Do you hear typically a lot of whining, pawing, and scratching from the creditors?
Well, creditors are tough.
Well, when they get the notice, because what happens before, you actually file it? I mean, do you let them know that, you're filing? I know I tell the clients generally, hey, listen, here's the deal. You can't tell them that you have filed bankruptcy because you haven't filed it. You can tell them you are filing because sometimes somebody will have a small claims lawsuit or other lawsuit that they have to show up on the return date, and so then what would happen is if somebody's aware that, and actually I don't have to do it until it's actually filed, but generally somebody's not going to take that chance. They'll just put it on the bankruptcy call. So when that happens, you send out letters to the other, to the creditors, correct?
Yes. Well, the bankruptcy court sends out notice once
before
it's filed.
Before you file it is what I'm saying.
Before that's filed, I just recommend that my client advises the bill collector or the creditor that they've hired our office, give them our name and number, and that kind of puts the creditor on notice that, hey, one, I can't contact that person anymore. Number two, maybe I'm going to stop any kind of court proceeding. I'm not going to spend any more money on court costs and filing fees because the debt's likely going to be eliminated when the person actually files.
Right. So have they ever, called your office, like I said, and had whining, and pawing and scratching, and just from a creditor perspective, because they know that if you do the bankruptcy, you're out.
Right. Well, my staff has. Thankfully, I'm sheltered from some of those calls. I do get a creditor call occasionally, but it's usually a friendly call. They just want to hear that you actually do represent that individual and that a case will be filed shortly. They want to make sure you're legit. Because a lot of people say they have an attorney when they don't because they know it's a little trick they can play.
Right, so to gain a little more time.
Yeah, creditor just wants verification, Jesse, so that they don't expend any more money on a client.
Basically, people should know that bankruptcy is available for them, Chapter 7, and they're able to go out there and they're able to discharge their debts if they meet these certain requirements. But they need to talk to somebody who is a competent bankruptcy attorney and who knows what those rules are because people have unique situations and unique kind of scenarios, and I've seen a bunch of those, and they want to be able, or they need to go to that person to be able to, who's going to help them, who's going to answer that question, and who's going to actually know the answer to that question.
Yes, and most attorneys who practice bankruptcy law in this area will provide a free initial consultation. I would be leery of any attorney that charges a fee for the first consultation for bankruptcy because the person doesn't even know if they qualify yet. They might just be gathering information. And really, I believe an attorney should give back to the extent that they can at least provide a half hour or so consultation without a charge. And that's what we do, of course.
And how typically bankruptcy consultation, I've been in all kinds. It's been, from maybe a few minutes or because sometimes you can't right away. For example, if somebody comes in and they don't live here, they don't have residence here, then you really can't do it. Right. So maybe 15 minutes, half an hour. I've been through all those scenarios, so it just depends.
Sure. It all depends upon the complexity of the case. It depends on whether the person has filled out the questionnaire fully. I've had consultations that have been 10 minutes. I've had some that have exceeded an hour. It really depends on the case, what's involved, what type of debts, what kind of income.
Right.
There's real estate transfers that go on that we have to find out if there was equity. So Chapter 7 is just a great way, Jesse, to get a fresh start.
Well, our viewers need to know that their life isn't going to the dogs just because they filed a Chapter 7 bankruptcy. What it means is they're taking responsibility, they are taking care of the problem, and doing what they need to do in order to support their family, in order to have their family at a level that they can live on.
Yeah, to me, it's one of the most successful things a person could do who's found themselves in this terrible financial situation. You can go from one day to the next, Jesse, from being heavily in debt to being debt-free. That is a very liberal, gracious, caring law that we have under the federal bankruptcy laws. So, and it goes back to biblical days too, so that you're not constantly a slave to the lender. At some point, the day of Jubilee, you get a fresh start and you get to live your life again.
Just so that you know, in the Old Testament, there is never an indication that actually happened, but that's exactly biblically based.
Well, Jesse, thanks for joining me today.
Thank you, Dave.
This has been Legal Action. We've been talking about Chapter 7 bankruptcy. We'll see you next time on Legal Action.